I've been asked to speak on the need for future FOIA legislation, and what I want to talk about are open meetings and the quandary that we find ourselves in with regard to open meetings under our Freedom of Information Act. Particularly, the Supreme Court has really confused the issue. So I'm going to take you kind of through the process of what's happened with regard to our open meetings in Arkansas. For many years, in both Attorney General opinions as well as Supreme Court opinions, the Pickens opinion, this quote appears. In essence, says that the conduct of our public business does not merely consist of the final result reached, but also is rather a spectrum including all phases of the process that how the result is achieved, including the deliberations, the discussion, and the information gathering. Accordingly, the Freedom of Information Act gives the public the right to observe the entire spectrum, not just selective parts. And in literally case after case that I've been involved with, we've seen that because of technology in some instances, in other instances just conversations, but emails, text messages, and other electronic media, we're seeing that many of the discussions and deliberations are occurring outside of public view. There we go. The mayor of El Dorado case was one that in terms of meetings has been relied on over the years. The Supreme Court ruled that FOIA applies to unofficial meetings called to discuss any matter which foreseeable action may be taken by the governing body. So when you've got, and generally I've found that these matters are generally on very heated issues or very sensitive issues. It could be the mask mandate. Recently we've found that the Huntsville school board, they were having text messages, exchanges, discussing and deliberating the mask mandate. The public needs to be aware of those because that is certainly, and it did happen, was a matter that would reasonably, that action would be taken on by the governing body. So many years ago, I think it was 2007, we took, I was actually personally the plaintiff. We went all the way to the Supreme Court on an issue where, in essence, in that case, our city administrator had sent out a memorandum, and it wasn't just our problem with it wasn't just an informational memorandum. It had the result that the administrator wanted the body to achieve, and they had conversations. We took depositions of those people, and I don't think we got as you heard this morning, the facts are everything. I don't think we got all the facts when we asked about what the discussions were, but I think decisions were made, but it was hard to prove. But we appealed that case to the Supreme Court, and what the court said was they ruled against us on that FOIA violation issue, but in their rationale, they talk about, look, it's not our responsibility. These are topics for the Arkansas General Assembly. We've seen that, and we have three legislators, representatives in the room today, and we really appreciate that. Representative Boyd, Representative Cindy Crawford, and Representative Lowry. We appreciate y'all being here. They're saying it's your job to create a definition of the word meeting. And that is so critical because as we're going to talk about another Supreme Court case in a minute, it's really muddied the water, and it's not just the citizens who are being hurt by this. It's also governing bodies, they don't have a clue as to what a meeting is. So it's the legislature's job to define the number of members present to constitute a meeting. And they had like 7 factors. We've noted 3. Whether citizen contact with one or more members is a meeting. Whether communication by electronic means is a meeting. Whether administrative staff contact for any purpose, including serving as a straw man at request of one or more members, is a meeting. So, this act, the Open Meetings Act, since 1967, our city of Fort Smith made the argument that emails wasn't included in the act, so that could not be a meeting. Supreme Court, in the Wade case, which has decimated open meetings, in my opinion, did clarify that issue for us, but it should be clarified by legislation, not necessarily the Supreme Court. And they admit that. We've seen this discussion, obviously, where the legislature has said, look, Governor, you're taking too much power. Well, the judiciary in this instance is trying to give power back to the legislature. June Bradshaw was a case that in Fort Smith where it was an email exchange by our 7 school board members where they elected their officers by a secret email chain. We took it, we asked for a summary judgment saying there's no genuine issue of fact. Judge Tabor granted our summary judgment stating that was a violation of FOIA. But I'm telling you, even under those facts of that case where 7 school board members are having an email discussion and electing the school board officers, under the Wade case that we're getting ready to talk about, that would not be a FOIA violation. And that is scary. This is a Larry Austin case. It was where there was secret text messages where they ended up making a decision to fire their mayor in Mansfield, Arkansas, and Mayor Austin came to us. This was pre-Wade. We're going to be talking about pre-Wade decision. Before Wade, it was pretty clear, that they admit that there was group text messages were sent between council members in violation of FOIA, and this constituted an illegal meeting, which were not public and there was no notice given. We heard about notice requirements. The media was entitled to notice of these meetings, and they were enjoined from conducting future businesses through these text messages. This was a strong order, but you're going to see what's changed after the Wade decision. This is Bruce Wade versus the city of Fort Smith. Again, this case went all the way to the Supreme Court, and they referred to the McCutchen case we just talked about, and they say this was secret emails trying to fire trying to do away with the Civil Service Commission. Again, a highly contentious issue. Rather, like the communication in McCutchen, the emails here contain information, a recommendation, and unsolicited responses with no decision. So basically the Supreme Court is saying, hey, the city administrator didn't ask for a decision, so there's no meeting. There was no decision made. That's what the majority held. I mean, so in essence, there's much confusion because if you read this opinion literally, because there was a strong dissent in this, dissenting opinions by Justice Hart, dissenting opinion, very strong in terms of opinions. It says, perhaps unwittingly, the majority has imposed a requirement that to be a meeting, an email must directly solicit a response. So somebody in that meeting's got to say, how do you vote? You got to, the 7 that are there, they have to render a decision, not just discuss business. and involves more than 3/7 of the board of directors, because in this case that we took all the way to the Supreme Court, 3 out of the 7 made a decision. They were discussing, they were in agreement that they were going to do away with our Civil Service Commission, and you and I had no knowledge of that. And then Justice Hart says, still yet, these determinations will almost certainly require a lawsuit to resolve. And she's exactly right, and or legislative action. And that's the reason that Robert Steinbuck, who wrote the FOIA book, and I brought before the legislature this last time a bill which would clarify this law. It never got out of committee. We testified on it. It never even got a whiff to get out of committee. Let me see. This is another dissenting opinion. Well, this is Justice Hart going on, and she said, in the case before us, the email group was established to discuss public business, which the directors obviously did. By the way, I just had another FOIA case, got a judgment against the city of Fort Smith by this same email chain where they're sending out emails, still discussing business, and they refused to give me the email chain, so we had to sue them. But today's majority opinion denies the electorate of Fort Smith insight into the performance of its elected officials and allows those public officials to make their decisions in secret. See, this is a Supreme Court justice. Secrecy is poison to democracy. On that point, I respectfully dissent. She sees the problem. This is Justice Wynn in the Wade case. The discussion by the board members in a non-public forum makes this case clearly distinguishable from McCutchen. The fact that the responses by certain board members were not solicited by a city administrator is immaterial. So the Supreme Court in Wade says, well, unless the administrator is saying, how are you going to vote, it's no meeting. But if they just get in there, I mean, they could just as well, if you apply this to in-person meetings, the same concept, they could go down, 7 of them could go down to the local McDonald's, get in the back room, 3 of them have the discussion, come to a conclusion that this is what they're going to do, and the rest of them sit there and don't say anything, and that is legal under the Wade decision. Does anybody see that that's a problem? I mean, if they're doing it on an email chain, the Supreme Court says it's not a meeting. All right. This is another case that I had on file. Again, involved emails where they were considering important city business in Ozark, Arkansas. After the Wade decision, their smart lawyers down in Ozark filed a motion for summary judgment saying there's no longer any issue, Judge. We can have these electronic communications. These communications do not meet the criteria set forth in Wade, and the complaint must therefore fail. Right? So it's kind of hard to argue when the court says you got to have this, 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 and this to have a meeting. So in essence, the city of Ozark was allowed to have their meeting by email exchange. We didn't see it. We don't get to see how the sausage is made. They go to the meeting and the sausage is already made and they cast their vote. And as Bill Ray Lewis always says, there's 2 parts to FOIA. There's the open records and there's the open meetings. We used to say that we had the strongest FOIA in the country. We're still holding pretty strong on open records, but open meetings have been decimated. And I'm telling you, there are meetings violation. You talk about a pandemic. There's a pandemic on meeting violations. Involved in a case over in Huntsville right now. This morning we heard about the great law that was passed by Representative Flowers in they've got to go back to the legislative session. They got important business. By Representative Flowers that said that you have to record meetings. A great law, and you have to keep that law for a year. Well, Huntsville, they claim they recorded the meeting, but they recorded over it. And secondly, in terms of open meetings, they didn't give notice to the local media as they were required to do. And again, on very, very important issues. We've already talked about the mask mandate that they violated by these text messages, but the other involved assaults on our sexual assaults on children. And if we're not able to see these discussions, that's very concerning. Robin Reeves, this kind of show, this was post-Wade, the post-Wade case. This shows how now the orders are watered down. Defendants admit that these text messages and SMS exchanges prior to the regularly scheduled meeting could be construed as a violation of FOIA and would therefore constitute an illegal meeting under FOIA, as the messages were not exchanged in public and notice meeting. So, you know, they don't say, like the prior order we saw, that this is a violation of FOIA and take response. They say it could be, because Wade allowed them off the hook. This is a recent proposed order where, again, they're using this same watered-down language. The defendant admits that certain text messages were exchanged between members of the board on the topic of in response to the COVID crisis. While the parties disagree whether the exchange was an improper meeting under FOIA, the defendants are willing to agree that such message exchanges should not happen in the future. Well, if it's not a violation of our open meetings, why are they agreeing that text message exchanges should not happen in the future? Because they know that the Supreme Court in the Wade decision has confused the issue so much. But it's just like we heard the experts talking this morning at the Attorney General's office. They say if there's two people present, that's a meeting, and you better watch what you're doing when you're discussing business. As the El Dorado case said, it's reasonably foreseeable to come before the body. I mean, so this is why we have to get involved, and we have to push legislators and show them why this does not meet the intent of FOIA that we've had up on the screen all morning. I mean, sunshine has to be shown on these things. It's the best disinfectant. Okay, so this is proposed legislation that we're hoping will get out of committee and voted on and passed in the next legislative session. That a meeting means a discussion among 3 or more members of the governing body about a matter relating to public business on which it is reasonably foreseeable that the governing body could take action. So if they're having these discussions, then they have to give notice to the media, right? One of the things that probably hurt us in our attempt to get this legislation through last time was we had the number 2 right there. And because personally, we felt like that if 2 of them are discussing our public business, that's a meeting. But, you know, 3 clarifies the law, because the law is confusing right now, and I don't think any governing body wants to take that chance, because I'm going to sue them if I find out they're doing this. because I think the law is so confused that nobody knows what the law is. Like Justice Hart said, it's going to take a lawsuit to clarify this unless the legislature does it. Meeting includes discussion in person, by telephone, electronically, or by other means, so we clarify that issue. The Supreme Court's clarified the issue in the Wade case because the city of Fort Smith argued, as I said before, that emails could not be a meeting. Serial one-on-one conversations, informal or formal, with members of the governing body by one or more members, employees of the governing body to discuss the body's business. So if they have the discussion here, then I go to here, then I go to here, serial discussions. And then it defines what the governing body is. So in conclusion, and I'm going to probably cut it off there. These are some other issues, in my opinion, that we could make ground on. You know, I can't think of any more important legislation than clarifying what a meeting is. For the legislature to say, this is a meeting, because it obviously prevents secret meetings. They can't make that argument, but it also protects the governing body. They can, you know, their lawyers, their smart lawyers can't say, well, you know, you can do this or you can do that. Did you have a question, sir? Okay. So other areas that I think propose changes, adding teeth to FOIA, we hit on that this morning. Extending the notice requirements for special meetings. I know we've got some media folks here. 2 hours sometimes you've got to give 2 hours for a special or emergency meeting. I would assume that could cause some problems at times. If it's an emergency meeting, I guess I can see that, but a special meeting to discuss an issue that has no emergency and you only have to give 2 hours, that doesn't advance the cause of FOIA, in my opinion. Requiring a response if no documents exist. In the case that we just had against the city of Fort Smith, where Judge DeLay issued an order saying violation of FOIA, we asked for these documents, and then a day or two before the hearing, they produce all these documents. But they never said, we don't have the documents. You know, they were trying to make a claim they didn't have the documents, which they did. But I think that it's only fair that if you file a FOIA request, if they don't have the documents, then tell me so. Then just say I don't have them. And you know, there's a Attorney General opinion that says just that. But again, as we learned this morning, the Attorney General opinions are only guidance, and they're not the law. The other one, requiring an exemption to be cited when you're redacting. In other words, if you're asking for an exemption from the law, then, you know, tell us why. Why you're doing that. So those are some of the changes that, again, as we talked about this morning, being proactive and not defensive all the time on the people's law, because this is the people's law. I've heard Dr. Lewis say it 1,000 times. FOIA is the people's law. It was the crowning achievement of the Rockefeller administration. A Republican governor in the midst of all Democrats. He was able to get this through because, as I think we've all learned this morning, FOIA, sunshine, open government, it's not a Democrat or a Republican thing. It is a freedom thing. So, yes, sir. Yes. Yeah, and you can Google it. There's been many extraordinary press articles on it in Huntsville, where basketball players were permitted to sexually assault other players. And we have filed a FOIA, and recently we've got an admission that the district had at least 9 FOIA violations. We've also filed a Title IX action. So I think the point being here is the issues, and the other side would argue, well, Judge, we want that redacted. We don't want them talking about what occurred with, and we're not listing names or anything like that. We're just saying, here's what happened. But the point being is, you got to put this in context. The issues that they're secretly talking about are issues that are of utmost importance. A scale of 10 out of 10.
How do you go around the school board?
I'm sorry?
The school board.
What?
How do you go around them?
How do we what?
How do you go around the school board?
How do you go around the school board? I mean, we talking about that. How do you challenge the school boards on that kind of information also? When you have to go through them to get some kind of information?
Yeah, you asked the administration, I want these records. And I want, for example, in the Huntsville case, I want the recording. Provide me the recording of the meeting. They can't do it. Provide me the notice to the media. They can't do it. Yes, sir. And I know we've got to move on here.
The law basically says custodian of records. That's who you go to. You don't go to the board. You wouldn't dare. I wouldn't dare.
Point, a great answer. In the city of Fort Smith, we send it to the administrator. And look, you can call them up and just ask them. I mean, they work for us. We don't work for them. Let's always keep that in mind. Call them up and ask them, I've got information I want to request. Who's your custodian of records? Well, then let me speak. If you don't know, then let me speak to the mayor and ask him. We vote him in. He should tell us that information. So just ask. I mean, it shouldn't be a guessing game. And if they're being transparent about it, they're going to tell you that. That's a great question, sir. I appreciate you asking that. All right. So if there's no more questions, we're going to move on to the next panel.